Nice, wait. Okay, hi everyone. Welcome back to today's podcast, which is Legally Black and White. So, as you know, I'm Myra, your host, and today's topic we will be covering corporate personality, limited liability, and when courts pierce the corporate veil. Sounds dry? Please don't worry. We're turning legal mumbo jumbo into actual tea we can enjoy. So, joining with me today in this episode is Ilyas, our corporate law dictionary.
Hello everyone, I'm so excited to be here.
Oh my
Not gonna
God,
lie.
not gonna lie. Nice. Okay, and then we have Daniel, our money brain.
I'm ready with spreadsheets all in my head.
All right. And then we have Kai, the case law machine.
Hello everyone. Thank you for having thank you for having me, Myra.
Mm.
I got cases, receipts, and also opinions.
Ooh, perfect. Okay, now let's dive in. So I want clarifying questions, interruptions, and also debates. So normal panel energy. So if there's something wrong, just argue, guys. Okay, so let's go. Yes, I'm gonna be starting off with you first. So, what is corporate personality? Explain like someone thinks SSM is just to laminate certificates.
So, Myra, corporate personality is the legal principle that a company, once properly incorporated, become a separate legal person from the individuals who founded it, own, manage, or controlled it. In Malaysia, this principle is enshrined in the Companies Act, what?
Oh my god,
2016. 2. Statutory touchstone, which is under section what?
20.
Yeah, under section 20 of the Companies Act 2016. This provides that a company has the capacity, rights, and privilege of a body corporate. In plain terms, the company can own property, enter contract, borrow money, sue, and be sued, etc. The company legal identity is distinct from the identities of its shareholder or director. The next section. This is my favorite section during my study during law school. Section 21. Can you do some for me? And the Companies Act 2016, which is protect outsider, which are the third party. Dealing with the company by validating acts done by the company, even if those acts exceed internal limits. For example, where directors act outside the constitution, third party can rely on the company apparent power. So the practical upshot in this, Myra, if you
Me?
and me
You?
form a company
Together.
like Myra and
Myra and
Ilyas,
Ilyas. Myra and Ilyas.
Sunjan Berhad.
Myra
Let's say
and
we make a mall,
Ilyas.
something like that.
Myra and
The
Ilyas.
company can sign a lease, borrow with its own asset, and if it's sued by Myra, by not by you, by Kai
Uh-huh.
or Daniel or anyone else, any third party that sued us, the suit is against the company, not automatically against our personal bank account. So it's not going to touch our bank account, but the company.
Oh my god, okay, sounds good. But wait, hold on. So even if my constitution says no selling croissants on Sundays, and then we just do it, someone can still rely on that contract?
Right. That's the protection protected under section 21, which it gives to outsiders. The law says the company's dealing are enforceable so that third parties aren't left guessing whether the internal documents say yes or no, Myra. The doctrine prevents directors or members from using internal limits to defeat outsider rights.
Yes, and historically, this came from the landmark case, which is the case of Solomon against Solomon and Co. Limited.
Your lecturer favorite? Who's your lecturer?
Azlan.
Oh my god, my lecturer also.
1897 SC 22, where the House of Lords held that once a company is validly formed, it is a separate legal person, notwithstanding that one person, Mr. Solomon, essentially control it. And that case is the OG authority, where the company is a legal person.
So basically, like the company is a like new legal human. So, but does that mean nobody is ever liable personally?
Good question. Let
Oh, I
me
know.
answer it.
Please.
Not necessarily corporate personality is the starting rule. There are exceptions and limits, which we'll get to after this. But the basic rule, the company is legally distinct from the people behind it.
Oh my god, behind me. Alright, I guess. Okay, Now, Daniel, since you handle all the money, you have like thick pockets, thick wallet, right? Okay, so tell us what limited liability actually gives shareholders and where it doesn't protect people.
So, limited liability is a companion concept to separate corporate personalities. For companies limited by shares, shareholders, financial exposure is limited to what they have agreed to pay for their shares, typically the unpaid portion. In statutory terms, Section 10, subsection 1A of the Companies Act 2016 identifies companies limited by shares, which states members' liabilities limited to unpaid amount of shares. Practically, if you hold fully paid shares worth RM100, your loss is only 100, Mara. Creditors cannot generally reach for your house or your personal savings for company debts. Okay. And on the other hand, Section 18, subsection 1 of the Companies Act 2016 describes liabilities of members according to the company's type, limited by shares or by guarantees. For example, members' liabilities are defined by the company's form. Why this matters, Myra, is because investors are more willing to fund enterprises knowing their personal liability is capped. It creates capital markets.
Oh my god, so sexy for investors. Wait, hold on, but how about directors? You guys are still on the hook, right?
Yes, very much so. So, like under the Companies Act 2016, there are a few sections that impose the duty and also limit the indemnities. So, under Section 192 up till 196 of the Companies Act 2016, these under this section, it deals with the indemnification and also insurance for the directors. Crucially, they set the boundaries on when the company may indemnify a director. So directors can be indemnified for willful breaches, fraud, or deliberate dishonesty. So if a director engages in negligence, breach of duty, or even fraud, indemnity or insurance won't shield them from the personal liability.
Okay, let me add on a bit.
Please.
So, to put it practically, shareholders enjoy limited liability for the company's debt, but directors owe fiduciary duties and statutory duties and can be personally liable if they breach those duties or commit wrongdoings. That's why good directors buy D&O insurance for legitimate business risks, but they cannot insure away fraud.
Okay, so basically shareholders are safe, directors less so. But what's the test courts use to pierce that safety barrier? Kai, you have any idea?
Okay, so yes, the baseline rule is that um,
What is the best one?
oh, sorry. I'm so sorry. Sorry, I got
I'm
confused.
here. Can you talk to me and not your?
Okay, so the baseline rule is that courts will respect the corporate separateness unless there's a compelling reason to look behind the company. So there are two landmark cases, which is the case of Hotel Jayapuri Berhad
Oh my
against
god. Okay,
National
I
Union
know.
of
Yeah, I know.
Hotel, Bar and Restaurant Workers 1980, 1 MLJ 109, where in this case the workers tried to treat the company and its owner as identical. And the court held there was no fraud or sham and refused to pierce the corporate veil. So the message in this case is mere ownership or even single person control doesn't by itself justify lifting the veil. So another case is the case of Teo Shi Kian against Red Rose Restaurant Sdn Bhd 1996 for MLJ 76. So the claimant attempted to hold the director personally liable, but the court found that the company was a proper trading vehicle, not a sham. So the veil stayed intact.
Let me add on to that, but
Please.
before we move on, I would like to say how impressed I am
Oh my
with Kai.
god.
She
She's
was
so
able to cite
good.
all the full case law
She's a
with all the
walking,
MLJ.
yeah, she's a walking LexisNexis guy.
Yeah,
This is the face
walking
of LexisNexis.
LexisNexis. So, if I may add on to that, court reasoning
Please.
in this case follow Solomon. Incorporation creates a legal entity and there must be something more than mere ownership to pierce the veil. the law does not lightly treat incorporation as a sham.
So the courts are like strict parents. I have strict parents, guys. By the way,
I
just
do,
for
me
information, you
too.
too. Oh my god,
Yeah.
we complete each other. Oh my god, we literally complete each other.
Yeah.
So basically, the courts follow the rules and don't switch your phone. But if you're hiding stuff, then they will. So lead us into that. Okay. So basically, showtime. When will courts pierce the veil? I want categories, statutory hooks, and cases. Please don't skimp on this.
Okay, there are several well-recognized grounds, which is like fraud, sham, evasion, misuse of group structures, and statutory provision that directly impose personal liability. So, let us tackle that in order, shall we? So, the first one is which is fraud or fraudulent trading, which is one of the big one. If a company is used as a vehicle for fraud, they deceive creditors, hide assets, or carry on business dishonestly, courts will pierce the veil. The Companies Act 2016 includes criminal and civil mechanism. Section 539, Companies Act 2016, stated that criminal liability where a person is knowingly involved in the carrying on the business with intent to be defraud. Section 540, Companies Act 2016, stated that addresses fraudulent trading and allow the court to make person knowingly party to carrying on business with intent to defraud liable to contribute to company assets.
Anything else?
Okay, so one of the case you guys can look at the case of Aspatra Sidang Berhad against Bank Bumi Putra 1988 1 ML 97CA involved the company being used to hide their assets and avoid the creditors. So the courts look at the substance of a form and expose the real controllers. When courts see deliberate deception, they pierce the corporate veil to hold the real directors accountable.
Okay, for example,
Okay.
imagine a director
Okay,
siphons
imagining.
funds into a shell company they control, then declares bankruptcy. If evidence shows the shell company existed only to defraud creditors, the court can order contributions back from the director personally. So
Okay.
basically, he gets money, you have to give it back.
So it's just not bad business lah. It's dishonesty. Got it.
Yeah, so now when we look at the sham or facet companies, so basically a company set up as mere facet and is existing only on paper with no real independent business and it can be disregarded. So the test is whether the corporate form is being abused to conceal the true facts. So one of the case is the case of Gatri Sidam Berhad against Muni Aman 1971
So impressive.
1 ML69
So impressive.
is an example where the court found that the company was used to avoid legal obligations and therefore pierced the veil. And the courts look at whether the company's former existence masked the real identity or purpose.
See, I tell you, she's a walking what?
So
LexisNexis.
impressive.
Yeah.
Running LexisNexis.
So, the difference between mere single shareholder control and a sham is important. Why? Because a single shareholder company is lawful. A facade set up to defeat legal claim is not. So, Daniel, do you have like any thoughts on invasion of legal duty?
Okay, moving on to invasion of legal duties. If a company is formed purely to avoid pre-existing legal duties, for example, to avoid paying a judgment debt or statutory obligations, courts may disregard the corporate veil. Basically, Section 540 again is relevant in this scenario because um, it it deals with financial assistance and can be used to probe intent when corporate structures mask transactions. The case that I can cite is Koh Kim Tak v Gan Siu T 2021.
Okay.
In this case, it involved a company used in a scheme to defraud investors. The Court of Appeal pierced the veil and held the real actors responsible.
So the key idea is basically purpose, is it?
Yes.
If the purpose of the company is to defeat a legal obligation, courts will look through it, is it?
Yeah.
Okay.
So, in misuse of group structures, on the other hand, Modern commerce commonly uses group of company. The Companies Act recognizes holding or subsidiary relationship. Section 7 of the Companies Act 2016 define holding and subsidiary companies, but being part of a group does not by itself pierce the veil. However, when group companies act as a single economic unit, carry out sham transaction among themselves, or one company is the puppet of another, courts may look behind the corporate structure to prevent injustice. Evidence of centralized control, transfer of funds to avoid creditors, or group devices to hide real ownership can trigger veil lifting.
Okay, so for example, suppose a parent company shift all the assets to a shell subsidiary right after a creditor wins in judgment, and the court will look for the substance and may set aside such transfer. So basically, there are express remedies or legal duties in the Companies Act that can make the persons liable without relying solely on the common law, which is person doctrine. So if you guys can look under the section 213 of the Companies Act 2016, it tells about the director's fiduciary duties, which can lead to remedies. And under section 218 of the Companies Act
Oh my god.
2016, it explains on the duties regarding improper purpose, where include the director must exercise the powers for the proper purposes. And under section 346 of the Companies
Another
Act
one.
2016, thank you, Elias. It tells you about the operation remedy where the court can grant relief where conduct is oppressive, unfairly prejudicial, or unfairly discriminatory. And in some cases, it opened the corporate structure to effect relief. For the section 588
Oh my
of the
God.
Companies Act
Oh
2016,
my god.
it tells you about the false or misleading statements in the financial statements, either in criminal and civil consequences. So for the section 609 of the Companies Act 2016, it explains on the liability for the false statements against civil or criminal implications.
Okay, so basically in practice, plaintiffs often rely on these statutory routes and evidence of sham or fraud. The presence of statutory offences means regulators and the courts have direct ways to pursue directors and other beyond old common law principles.
So that's low key kind of a lot, guys. This is too
Yeah,
much for my little
we
brain
need to
right now.
relax. Yeah.
So let me get it straight. Sometimes the law pierces the veil because of fraud,
Yep.
but then sometimes the statute gives authority to hold people liable. I do, but sometimes because of group structures are being used as traps. So, oh my god, this is too much, guys. I'm gonna cry. So, any final thoughts on how courts approach the
Oh my
test?
god, relax, girl, relax. Look at
What?
Kai. Not just she's a walking LexisNexis.
Can I just look at you?
She got all the statue all in her head. The way she's citing all the section just now, it's impressive.
Oh my god.
So what you saying just now? The court look at substance over form. Okay?
Yeah.
The court look at substance over form. They inquire into purpose, conduct, and whether the corporate form is being used to perpetuate wrongdoing. So there is no single litmus test. Do you know what this litmus test? It was like the one that
Oh
we
my god, in
do
science class?
during science
Oh my
class.
god,
Yeah,
throwback.
the litmus test. Each case is fact sensitive.
Okay, sensitive, I guess. So, okay, now moving on to quick hypotheticals. So, just basically, I want real practical takeaways. Kai, give a
Ooh.
creditor scenario. If you can think of one, because you're so smart.
So, okay, for example, like the credit scenario lah. So, Bank A lends 2 million ringgit to company X. Afterwards, the director transfer all meaningful assets to the company Y, which is a separate company they control. So, the Bank A sues when the company X collapsed. If the evidence show that the transfer were made to put the assets beyond reach, Bank A can argue that the transfer were fraudulent, and the court could pierce the veil and hold the controllers personally liable under the section
Oh my
540
god.
and by tracing the assets.
Okay, now let me tell you what directors should do.
Tell me.
Directors should document the decision making, obtain independent valuations, independent directors for conflicting transactions, and ensure distributions or transfers are commercially justified and not timed to defeat creditors. Good corporate governance is the firewall to all this.
So, for investors, on the other hand, limited liability remains powerful, but don't assume it's absolute. If you personally guarantee a loan or if you engage in wrongdoing, your personal asset could be at risk, Myra.
Oh my god. Okay, so limited liability, good, nice. Fraud, nasty, nasty, naughty. Okay, so moral of the story: don't be shady. All right. So to just finally wrap this all up, quick bullets from each of you.
So for me, corporate personality, which company is a separate legal person. Key statutory anchors Section 20 and Section 21. Companies Act 2016. So the landmark authority in this are the Solomon v. S. Solomon and Co. Ltd. 1897 AC22. See, I
My
remember
God.
what Kai stated just now. Respect the corporate form, but don't weaponize it.
Okay, for me, limited liability protects shareholders, such as seen in Section 10, Section 1A and Section 18, Clause 1. But directors and controllers can be personally liable for fraud, breach, and bad acts. And this refers to Section 192 to 196, Section 539, Section 540,
Oh my god.
Section
Oh my god.
588,
Oh my god.
and last
Oh
but
my
not
god.
least,
Oh my god.
Section 609.
Too many. Too many.
Section 67.
No
Okay,
609.
for me, the courts will uphold the bail in usual circumstances. For example, in the case of Hotel Jaya Puri Berhad against National Union of Hotel, Bar and Restaurant Workers, and also the case of Teo Shi Kian against Red Rose Restaurant Sdn Berhad. But they will pierce the veil for fraud, sham, evasion, or even misuse of groups, and where the statutory provisions allow.
Okay. I guess that's gonna be it for today's episode. Thank you so much, Elias, Daniel, and Kai. Your
Thank
information that you have shared with me, with us today, is very informational and very good. Daniel, don't go to sleep now, okay? So this is the kind of legal tea that I can drink, that I can, digest. So, listeners, everything that they have quoted, the statutes, the cases, please take this into consideration and don't go to waste. Kai literally mentioned all those cases, all the citations and everything. Please also remember, okay? Please try to be like Kai. So yeah, I want to thank for today's sponsors as well, which are two companies, my beloved Kai City Bunga Enterprise and also Daddy and Gem Enterprise. Thank you so much for sponsoring today's episode.
Thank you.
And yeah, thank you guys for joining us today.
Thank you also
Thank
for
you all.
having us
Thank you. I
here.
love you guys so much.
Thank you.
Love you
It's
guys so
really
much. Okay,
great.
jom lepak lepas ni. Okay, so okay, bye.
Okay, bye
Thank you guys. Comment, like, and subscribe. See you.